The State of Utah versus Daniel James Fivas, Fivas. Did I say your name correctly, sir?
It's Fivas, but Fivas is
Fivas.
fine.
Okay. Case number 25-191-3803, set today for a scheduling conference and detention.
Yes, Your Honor. And so I think we would like to address the detention before we get the new date. So I have not yet seen discovery on this case. Obviously, it's going to be something where I'm going to need to be getting medical reports, and there's probably going to be quite a bit of discovery. So I am at sort of a disadvantage without that. However, I do think that in this case, the court should release him to pretrial services. I fully understand how serious the charges are here. However, as the court knows, we're not here to impose a sentence. We just need to be looking at whether or not he is a failure to appear risk or whether or not he's a danger to the community. Looking up his criminal history, and he's verified this with me, the only thing that I have found is that he had a Class A property crime that occurred several years ago. He pled guilty to. He was successful on probation. That was closed out successfully. He has spent much, if not most of his life in Utah. He has connections in Utah. He's previously had jobs in Utah. He has a residence in Utah. And I don't think that there's any reason to believe that he's a failure to appear risk. Similarly, I don't think that he is a danger to the community. These allegations, as serious as they are allegations regarding one child that was in his custody. Obviously, at this point in time, that child is not going to be in his custody. There's simply no basis in the probable cause statement to assume that he would be a risk to anyone at this point in time. If you look at the probable cause statement, what the allegations are is that he was failing to feed this child properly. There's no allegations that he's violent. There's no allegations that he has impulse control issues or outbursts. And so I think that this is a situation where he certainly could be monitored in the community while this case goes to trial.
All right, Ms. Radford.
Your Honor, there is substantial evidence to support the charges, and we do feel like he constitutes a substantial danger to the other children in this case, given, I mean, I don't know, has Your Honor been able to read through the PC statement?
I have read through part of it. I haven't read through all of it. I'm glad to hear your summary of it.
In this case, the defendant and co-defendant, the parents, the people in charge of taking care of this 5-year-old, the two people that she's relying on, not only failed to feed her, they deprived her of food. She was, I mean, there's not only from the words of the defendants, but also from another child that was in the house corroborating the story that they locked the refrigerator, they locked the freezer, the pantry, the garbage can at one point, because this little girl, or this child, this 5-year-old child was sneaking out in the middle of the night to get food. It's extremely concerning. When she was admitted to the hospital in August, she weighed the same as this is a 5-year-old, weighed the same as a 16-month-old. As she was absolutely starving. She stayed in the hospital, I believe, for 16 days and gained 8 pounds. Clearly, this isn't an issue of the child having an eating disorder. This is a matter of being deprived food and being prevented from stealing food. Apparently, she was so hungry, she's still in diapers and eating her own feces. This is a little beyond just not taking care of a child or neglecting a child. This is intentionally harming this particular child. In fact, they tried to get rid of her when they found out that they were pregnant with another child. They asked DCFS if they want this child anymore. That creates, to me, that is severely terrifying to leave other children in the custody of these people. And I would just ask the court that they not be given that chance to be around.
Tell me about the witnesses in this case and how the state would be able to proceed in this matter. The evidence itself. You've given me the proper. I'm just wanting to know that the evidence itself would be substantial. I'm just trying to figure that out. So I'm sorry.
Like the medical records.
Okay, the medical records, that would be part of it. Okay.
So there was a couple, The child was taken into the hospital twice. The statements by defendants, the co-defendant and the defendant, as well as the other child that were in the home, corroborates all of this, that
Okay.
there were locks everywhere.
So it's the medical providers and the other children that are in the home that would be able to support these charges.
There's only one other child that would be able to speak. The other one was a baby. 3 children in the home, one being the alleged victim, one being another sibling, and then a baby.
All right. Now tell me about what you know about the mother in this circumstance. Is there another party? I'm assuming, correct?
Yes, the mother. What would you? I'm not sure what you're asking.
So,
She
so as part
said
of,
the same.
so I think you've established that there is substantial evidence. In fact, not I think, there is substantial evidence to support this charge based on what you proffered and based on the PC statement as indicated in the information. But I'm now just reviewing whether there's clear and convincing evidence that he would be a danger. And I think you've indicated that he would be a danger to the other children in this home, correct? Would he be a danger to anybody other than the children in the home?
I don't want to speak to just mental illness in general, but to me, this is just shocking behavior in general.
Okay.
And Judge, could I address that?
Well, let me finish with Ms. Radford, and yes, we'll allow you to address that.
Sorry about that. I just wanted to clarify something real quick. So he is biological dad to the alleged victim in this case. The co-defendant is stepmom.
Okay.
Co-defendant and the defendant in this case are, when she found out that she was having a child. So they have another child together. Again, that's extremely concerning that they now have another child together, that he is the biological parent.
Talk to me about risk of flight. I know this is a first-degree felony, which is a pretty substantial charge. I want to hear what you would proffer with regard to that.
I mean, I think just the fact that the seriousness of this charge and the consequences for it are, I can't speak to whether or not he's going to leave someone's mind. I just know that he is charged with something very serious, and that's sometimes reason enough for people to leave. So they don't have to deal with those consequences.
All right. Counsel.
So just to address the flight risk, the seriousness of the charges can't alone be, enough to consider it someone to be a flight risk. As I said, his entire life is here. He's never shown any reason. There's no indication that he would be a flight risk. Additionally, as I said, on the one prior, the only case he's ever had, which was again a Class A case, he successfully completed. He was compliant with probation. He's done everything in his life to show that he is a responsible person and that he would be showing up to court. So there just simply isn't any risk that he's going to fail to appear. Regarding the statement that he is a risk to the other children, I don't understand where the state is coming from in assuming that he's going to have custody of these children at this point in time. Certainly the court can put in place, and I would expect that the court would put in place, if he's to be released, that he not have any contact with minors. And that would include, one of the children is not actually his biological child. The other one is his biological child, but I don't see any circumstance under which he would have custody of these children as this case proceeds.
He only has one other case. Is that what you said?
That is when I look up his history, and again, I don't have the discovery, but I see that there is one Class A theft by deception charge that he successfully completed. And certainly if the state has any other information, I would assume that they would be letting the court know that.
I'm looking at his other case right now.
I'm sorry.
I'm just looking at the other case that they had. All right. Anything else, Ms. Radford?
If I can't, one second, I'm just pulling up this. I guess my other concern is that just the cruelty and the depravity with which they treated this 5-year-old child. And if you're looking at the PC statement, well, I guess it's not the PC statement, but the motion for motion to hold. He and the co-defendant, along with the other child, concocted their stories to match, including the types of meals the victim had and how often. This case is concerning for a number of reasons, but the lack of accountability, as well as the admitting to certain behavior, but then saying that they had been doing something that they hadn't. They obviously had not been feeding this child regular meals, even though they came up with the same idea of what they were doing. This little girl, like I said, this child was eating her own feces. She didn't have a bed. She wasn't enrolled in school. She couldn't talk. She was isolated from everything. The concern is that this is extremely serious, and I would just ask that the court keep them in custody without bail.
Judge, I would just.
What is the status of the co-defendant?
She's the one that was called earlier that they just continued it. Did she refuse or? Oh.
And Judge, could I make one more comment?
Oh, sorry, what? That's with Judge Bates. Is this case with Judge Bates? Is this with Judge Bates as well? I'm sorry, go ahead.
I'm sorry, if I could just make one very brief statement. All of the things that Ms. Radford has said, those sound like those are sentencing arguments. The court obviously knows that he is presumed to be innocent. We're not here to punish him for something that he is presumed to be innocent of. The only things we're looking at is whether or not he's a flight risk or a danger to the community, and there's just nothing in the record that would indicate either of those things.
Well, I do find substantial evidence to support the charge. Really just the clear and convincing evidence as to whether he is a flight risk or a danger to the community is the issue. I am concerned that certainly that he would not have any contact with any other minors and that is a concern here. Taking into account the substantial evidence to support the charge and understanding that he is presumed innocent, but for this purpose, that's a different standard and a different review. I do find that he would constitute a substantial danger to the children, for sure. And this is an extremely serious charge. What is the tell me about his living situation.
So, Your Honor, he does have an apartment. He believes, he's hoping that he still has the apartment. Obviously, something might have changed given the time of that he's been in custody. In terms of the children, my understanding is that they are in state custody, or that's his understanding. So he's certainly not going to be, getting them back. But he did have an apartment. He still believes that he has that apartment. He does have some connections in the state and in Utah that he would be looking at if he has been evicted. But at this point, we don't have any reason to believe that that's happened.
I did note that it appeared as though he may have had issues with living situation. Oh my gosh. Frustrating when this computer freezes up. In the last case that he had, all right.
Trying to find the statute about presumption on a first degree felony of a presumption of.
Thank you. That would be helpful.
And if we want to pass this for just a minute, sorry, where I'm looking.
My grandfather's in the shelter. That's why there was a living situation at that time. That's I just forgot to clarify that. Okay.
Tell me that again. And Judge, to the court's question about his living situation, he's just informed me that during the first case, he was living with his grandfather, and then he ended up finishing up his probation in the shelter. So even though he did have, some difficulty in terms of housing at that point in time, he still was able to complete probation. And again, he has been in an apartment which he hopes and believes is still available to him.
It's 2 or 3. I missed 2.
Do we want to pass this for a minute?
We're just looking at the first degree felony presumption of custody.
I'm sorry. I'm just looking at the statute itself right now.
I'm sorry, what's the code that you're looking at?
I'm looking at 7720-201 and also 7721 subsection 8. Looking at those two, just checking to see if there's anything that covers this situation. All right, Ms. Radford, I'm not finding anything under this. Have you found anything that you can cite me to that shows there's a presumption that he should remain in custody?
Just all the reasons that I've given. I think there's concern that he would be, again, corroborating false statements with the co-defendant if he's released. And if you're releasing him, you'd probably have to release the co-defendant. So I don't see any reason why we should be releasing him at this time. It seems.
The co-defendant's going to be going before Judge Bates, it looks like, for that issue. And, I'm not Judge Bates, so, he'll make that determination with the co-defendant.
And there are.
This
Given
is
DCFS's
what we're going to do. I'm going to take a 5-minute recess and just kind of look at this
Thank
a
you.
little bit more closely. And we'll be back on the record at 12:15. Okay.
Thank you.
And Judge, if I could just say, since we are looking at the statute, my understanding is that maybe the presumption the state is talking about is with capital felonies, but this specifically says that they're entitled to bail unless there's a felony, when it's a felony where there's substantial evidence to support the charge by clear and convincing evidence, and that the individual would constitute a substantial danger to the community or is likely to flee. So I think that the court has to find that he, by clear and convincing evidence, one of those two.
Understood. Thank you.
I'll be back in 5 minutes.
Jared on to, we have him set up with.
All right, we're back on the record in the case of State of Utah versus Daniel James Fivas. All right, after having just reviewed the matter and taking everything into consideration, this is my order. I do find that, again, that the state has shown there is substantial evidence to support this charge. I'm also very concerned with the taking those allegations into consideration with regard to the danger as alleged in here. And I do agree that this is a danger to the community, not just to his own children, but to any other children. Based on the depravity of the allegations here, it would appear to me that there's more going on here than just simple neglect. There just seems to be issues with regard to how this individual, if taking these facts as alleged with the substantial evidence, that taking that into consideration, that would consider to this court to be a danger to any children, and therefore I'm going to deny the request for his release at this time.
Your Honor, could we please get a date? I do need to get discovery, and I want to make sure I have an opportunity to review that. So could we please set the next date, either December 11th or 22nd?
I think this needs to go before Judge Bates, right?
Oh, is this a Judge Bates case? Okay.
November 24th?
November 24th should be fine. Judge Bates has a calendar on November 24th? I mean, I'm just confused because he's usually.
We did set the other case for November 24th at 8:30, right?
Oh, I'm sorry. I was confusing. I saw that you had a 17th, which is.
That's a special set because
okay.
we don't have the 27th.
We can do November 24th.
So let's see where.
This is 8:30.
8:30, yes.